Good evening, everyone. I am Manya Khanna, Senior Associate of Operations and Corporate Relations, and along with my co-moderator, Ms. Shreya, welcome you all on behalf of Karuna Mediation and Arbitration Institute and our founder, Mr. Sahil Kapoor. Being a family dispute resolution practitioner and a mediation enthusiast, he founded Karuna Mediation and Arbitration Institute with a vision to spread awareness of mediation for resolving disputes with compassion and empathy. In progress and awareness towards our vision, we organize these webinars to spread awareness about mediation for students and professionals who all will be the future building blocks for this particular sector. We have announced our internationally recognized mediators training in January 2023 weekend batch in collaboration with EMS Solutions United Kingdom, accredited with IMI and CMC United Kingdom. This training has been done by Ms. Emma McHenry, who is an award-winning mediation trainer. After a successful completion of this training and assessment, you all will become an IMI qualified mediator, and you can learn and register for the badge at our company's website. So all about in today's webinar, we will be on, today's topic will be on mediation as a savior for consumer disputes. To impart and share knowledge about today's topic, we have with us two expert panelists who will throw lights to all the facts related to consumer disputes and how one can be successful in solving consumer complaints through mediation. I would like to introduce you all with our expert panelist, Ms.Veena Ralli. She has been practicing in Delhi High Court for about 4 decades as an advocate. She is an organizing secretary of Samadhan, the Delhi High Court Mediation and Conciliation Center, and leads over 260 impaneled mediators. She received her basic training in mediation in India and her advanced training at St. J. Queenie College of Law, University of Utah, USA, and the Stretches University for Dispute Resolution, University of Pepperdine, Malibu, USA. She is an accredited mediator with CI Arab, London, and CIMI at Singapore. Despite being a lawyer, practicing mainly in original side, and doing commercial practice, she is especially known for helping parties in family and matrimonial disputes. Considered the most challenging jurisdiction in any court, more so in mediation, where emotions run high and egos clash constantly between the parties, between of age of 2 to 93 years. Her Midas touch with people of all the ages has become legendary in the Delhi High Court. She has also been appointed as a mediator in several important and large commercial and family disputes by the Supreme Court and Delhi High Court. She has trained many lawyers, judicial officers, and even counselors attached to the family courts in Delhi and other states also. Now I would like to introduce our second panelist, Dr. Ashok R. Patil. He has been associated as a professor of law and chair of Consumer Law and Practice, Ministry of Consumer Affairs, Government of India, coordinator of Internal Quality Assurance Cells and NIRF. Also, sir has been published so many books in either internationally, nationally, articles under his names, and been associated with so many research projects related to consumer, online consumer mediation center, unfair trade practices, challenges, and the way forward, and many more. He has been a member of different government organizations like member of drafting committee on Consumer Protection Bill 2019, Rules and Regulations under Consumer Protection Act 2019, member of working group on consumer advocacy of Ministry of Consumer Affairs, Government of India, New Delhi, and many more. Sir has been associated as a board member of the International Association of Consumer Law, member of Consumer International London, United Kingdom, and a lifetime member of International Academy of Financial Consumers of Seoul and many other national and international organizations. It's a pleasure for us and for our audience to have both of you. Before proceeding further, I request to all the participants to please switch on your cameras and mute yourself if possible. Then only it can be a wonderful interactive sessions. I request the participants to please switch on your cameras, and all the questions from your side will be taken at the end. You can write it down with yourself, or you can send the message in the chat box. We assure you, or we try our best to have it in the last of the sessions. Now I hand over to Ms. Shreya Pandey to raise her first question to the judges.
Thank you, Manya. I would take pleasure in asking the first question. The question is, do you think the 2019 Act will help consumers to resolve their disputes through mediation more efficiently? How will this help to build mediation procedures in India in the future in resolving the consumer disputes? Sir, I would like you to first share your views on this.
Yeah, just a minute. Okay, thank you very much for inviting me and sharing my views on mediation, especially on consumer dispute mediation. So I was heading this consumer chair, which is established by Minister of Consumer Affairs, Government of India since 2008. And I was involved in drafting of Consumer Protection Act, rules, regulations under that. And always interacting with the ministry and other institutions on different area. So why we thought of mediation chapter in the Consumer Protection Act? Till Consumer Protection Act, no legislations in India were having independent chapter on mediation. Maybe one or two sections were there in different legislations, but this is the first time in India, Consumer Protection Act came out with the independent chapter on mediation. The reasons are many. When we established Consumer Protection Act 1986, till we have seen the progress and pending cases before the Consumer Commission. So that was a huge, even though the central government tried their level best, but ultimately they are little bit, India is having a federal system, state government and central government. Central government cannot interfere in the administration of the state, and state level consumer commissions are under the control of state government. Judiciary is not intervening in that. Hence, because of that, enforcement or intervention was lacking. That's why pending cases were more. And well, there are two national surveys done. One CUTS International in 2012, another one Indian Institute of Public Administration in 2013. Both the surveys clearly mentioned a lot of pending cases because of many reasons. So then the central government thought of how to solve this particular problem. And then the central government thought of coming out with a mediation under the Consumer Protection Act. So huge pending cases because of the state governments are not appointing the members on time, even though they know that when they will retiring, they will not start well in advance their appointment procedure, infrastructure problem. And now, see, these are the problems were there. That's why the central government thought of, let us come out with the mediation under the Consumer Protection Act. Now, yes, it's a new legislation, 2019 Act, passed in August 2019, but came into force in 24th July 2020. And still it is it's a child. Every state has to establish mediation cells. And in one case, cases pending before the Supreme Court, infrastructure for consumer commissions. So keeping that case pending, the Supreme Court directing all the state governments to get information how much new legislation is implemented. So in that regard, they are asking how many states in your state, how many, have you established mediation cell attached with Consumer Commission? So they are sending all these information to the chief secretaries of the state, and they are getting information then one step by step, they are going ahead. So it's a growing process. At present, I cannot say we have already successful. It's a growing. We are moving towards the success. So to that extent, I can say now.
Ma'am, please share your views on this, please.
Yes, Shreya, I agree with Ashokji on this. Of course, in India, officially mediation was introduced as per Code of Civil Procedure in the year 2006. It was the only concern at that point of time that there was a lot of burden on the system for providing service, justice. There was a lot of, you can say, bottleneck situation had arisen at that point of time. So a view was taken to go for alternative dispute redressal mechanisms. Over the last 16 years, mediation has been introduced at various levels before various authorities, more particularly all trial courts, high court, Supreme Court, everywhere. In many acts, mediation was stopped, of course, before even this complete comprehensive chapter in the Consumer Protection Act, like even in Companies Act, even matrimonial laws, particularly Family Courts Act, everywhere either mediation or conciliation word was stopped. But this act provided a comprehensive, complete chapter 5 on the mediation, based on what mediation rules were framed by various high courts when this concept of mediation was introduced. We read each and every provision of this chapter 5 and we feel that not even a single aspect has been left open, left behind, where we cannot set up our centers. Centers are being set up under this act as well. More particularly, I'm aware about Delhi, but they have not become very effective. There are many reasons attached to that. If you read the provisions about the fee of the mediator, that's the basic concern. The parties have to bear the fees of mediation process as well. A litigant, a consumer who comes, approaches this consumer, this forum for redressal of his or her dispute, maybe that he doesn't have enough resources to pay the cost of litigation, lawyer if required, though we say lawyers are not required in before the consumer forums, but still there is a cost involved. In this process, he has to bear the cost. But maybe he doesn't have the money, maybe he doesn't want to add on to the litigation cost. And the third aspect is people are not even aware about the effect of mediation. Mediation is not only helping to reduce the burden on the system. Mediation is only the process which looks at the relationship. In consumer also, we have a relationship in the sense we patronize the products. We buy product because I like Samsung, I buy Samsung. I like IFB, I buy everything of IFB, of any product. So this is in fact a process which gives you an opportunity to look at your need. If you need the product today, you can get it. You can get the product of your choice and at a point of time when you need it. So your need is addressed at a relevant point of time and you get product of your choice. Mediation gets you that. Maybe in the same way, it helps even the manufacturer, even the dealer, because the reputation of the supplier is also kept in mind, because if the matter is resolved in mediation, he also gets protection so far as outcome of the litigation is concerned. But for that, we need to have a lot of awareness. Without that, it becomes difficult. Thank you, Shreya. I hope I answered.
Yeah, thank you so much, ma'am, for the answers. Thank you so. Now I would like to raise my second question. My second question is, does the upcoming mediation law have any effect on the present mediation provisions provided in the Consumer Protection Act 2019? I request Veena ma'am to please share her views first.
Manya, I was called by the parliamentary committee also to give my comments as organizing secretary of Samadhan, and I have presented my suggestions there. I have also redrafted the contents of the proposed act from our side, because I was asked not only to give suggestion but tell us what is to be done at which stage. I did not find anything which goes against the provisions of the existing Consumer Protection Act. Rather, they support it. It will help us rather. If we look at the proposed bill, we are talking about the quality of the mediator. We are talking about the quality of the process. And we are talking about the enlargement. See, at the time of criminal matters and all were excluded absolutely from the proposed bill. Here also we have a list, those matters cannot be mediated at all. But those matters which can be mediated, I think we are going to be largely benefited by the provisions of the Act, because this is a time after 15 years of introduction of mediation in our country, when we have signed Singapore Convention as well, waiting for its ratification, where many countries have ratified. I think if we look at largely on the provisions of the Act, it will help us to improve upon the credentials of the mediator, quality of the mediator, and the mediation process. Because we will be supervised by some council, as most of the places you see medical council, even we have our bar council. So there will be some council, there will be some rules and regulations, there will be accreditations institutions, only those mediators will be recognized. So that will be, I think, helping us a lot.
So overall, ma'am, the head body is the main organizing one, which is required now, I think.
Somewhere or the other, see, right now what is happening, somewhere or the other, we need to get collected, and as a body, as an institute, everywhere mediators are working. But is there any accreditation provided by anybody? My answer is no. So at least there will be some accreditation. If you look at the accreditation process outside our country, it's very strict. They follow the rules and principles, and accreditation is given to people who take training, but they satisfy their criteria also. In our country, so far, what has happened, anybody who has opted to be the mediator, he's given that training of 40 hours and he's declared mediator. My answer to this question is that is 40 hours training sufficient? Will be that it is more likely getting a degree of law, and then working as an internship is required. Like you people have got an opportunity to get internships. You work with someone else. You understand the nuances of mediation. So then right now, anybody who gets that certificate can offer himself by saying, I am the mediator, I can help you. Maybe he's not in a position to hold the process properly, accurately, and the mediation outcome is not favorable to the parties. So we have to be basically getting perfection in the holding of the process. Outcome is any case in the hands of the parties, and that is possible only if we have quality of mediators.
Yeah, thank you, ma'am. Sir, what's your views on this, please?
I agree with madam. Only some concern. Before that, just I wanted to give a little bit how Consumer Protection Act redressal system is established, because some foreign people are also here. So this Consumer Protection Act 86 or 2019 Act, at the district level, see, as a whole India, we have a National Consumer Commission that is the top under the Consumer Protection Act. Below that, every state is having a state consumer redressal commission, and every state is having a districts. Every district is having minimum one district consumer commission. And if more number of cases are there, then more number of district commissions within the district. So this is the how three-tier redressal system is established, and it is having its own pecuniary jurisdiction and territorial jurisdiction. And at the end, against the National Consumer Commission decision, we can go to the Supreme Court. So this is the hierarchy it works. And every district commission has a power to appoint mediators. So this mediation cell should be attached with the mediation, the consumer commission. And who has to select these mediators? Mediators are selected by the district commission President and members. First of all, this Consumer Protection Act words used under the Act, intentionally those words are used which are not used in the regular civil court. So intentionally, they have not used those words. Plaintiff, defendant, court, judges, these words are not used under Consumer Protection Act because the Act wants the consumer has to come personally and argue his matter. So that is the object behind it. So that's why we call it as a commission, Consumer Dispute Redressal Commission. And who are deciding this commission, cases, they're called as a members and president. And even dress code is mentioned, what type of dress code they should use. So ultimately, whatever problems or fear is there in the civil court, that is removed and established here. The intention is party in person, consumer himself should come and argue the matter. It's a summary proceedings, less court fee, lot of merits are in this particular thing. And this, but under the new act, the power is given to the district commission, state commission and national commission to appoint the mediators. And who can be mediator? What is their qualification, disqualification, what type of cases are referred? All those things are given under the rules and regulations. Now question comes, even though mediation bill is there, act will become, then I want Veena Madam's inputs on that, especially what are the cases cannot be referred, mentioned here. Is it the same with the mediation bill? And what type of people can become a mediators under the Consumer Protection Act? Is it the same or is there any difference? And if there is a difference, is it prevails? So that also we have to look into, because all consumer cases cannot be referred. All consumer cases cannot be referred to the mediator. They have given matters not to be referred to mediation under Rule 4 of Consumer Protection Mediation Rules 2020. So if that is the case, then how the both harmoniously can be taken? So that is the one point. Second point, here even bureaucrats become a member. Everything is given. Eligibility for empanelment of mediators, retired judges of High Court, Supreme Court, Consumer Commission, then retired judges of district courts, then advocates minimum experience of 10 years, then the whoever worked in the mediation for 5 years, at least 5 years. So like that, they have given, nowhere they have mentioned accredited mediator, or there should be a training of these people. So it is a silent in the act. So that's why wherever silent, how we can bring the strong that mediation act, some places it can prevail. Another point which I now recently, maybe 6 months back, National Consumer Commission given an advertisement saying that whosoever is interested to become a empaneled mediator, you can apply in this format. And I also applied that format, and then they scrutinized all the applications. They made a two list A, list B. So list A, whoever undergone the mediation training, accreditation mediation training of 40 hours, those people are put it in the list A. And who have qualified as per that eligibility rule, it's a regulation 3 of 2020, where retired judges are there, but they have not undergone the training. See, mediation is, everybody cannot be done this mediation process. It's a special skill. So that's why the another list is made, list B. So maybe that who have not undergone the training, those people are put in the list B. Maybe in future, they will be trained, those people, and then only the cases can be allotted to them. So these are the some gray areas still exist. Maybe in future, we will get a clarity more on these aspects. Thank you.
Thank you, sir, ma'am, for sharing your views on this. My third question is, people are still very much aware of, people are still very much aware of the mediation and its legal backing. How to encourage people to choose the procedure, especially in consumer disputes? So please share your views
Yeah.
on this.
See, there are challenges. First of all, I'm coming to the basics. First of all, every district commission, state commission, national commission should establish mediation cell. And again, infrastructure is needed. And now, we are going towards a digital India. So online mediation is coming up. So we are encouraging that. Even consumer ministry is working on online mediation. So for physical mediation or online mediation, infrastructure is important. So now the central government is providing some assistance to the state commissions and district commissions to establish these mediation cells. That is the first stage. And second stage, especially around 0.3% of aggrieved consumers are approaching consumer commission, 0.3% as per the national survey. So rest of the still people are not coming forward, even though their rights are violated, they are not coming forward. There is the need of why they are not coming. So we are working on that. And as madam said, awareness is very, very important. So now we are requesting district commission and state commission in your district, you do awareness programs about the Consumer Protection Act, about the mediation, so that more number of cases will file and it can be encouraged mediation. So this is a second point. And another point suggesting to the even ministry also, if you always, this is a practical problem, every state has, whenever welfare legislation comes into picture, implementation is the problem. Legislation is very good, but when there is no implementation, whatever object of the legislation may not be achieved. So in that regard, what I suggested, that every district or some of the states are having very reputed mediation centers, private mediation centers. Why not you recognize those mediation centers? You put a yardstick. If they are qualitative, recognize, otherwise reject it. Once you recognize, then whosoever working in that mediation, private mediation center, you accredit as per your rules and regulations. Then whenever case comes, if you don't have an infrastructure, refer it to the mediation, private mediation centers. So they will help you to dispose of these cases. So that also I'm canvassing before the central government as well as state government, but still it is under process. This is a one stage. And also about the problem is, as madam said, fees. Fees is the major problem here, mediation fees. So up to 5 lakh rupees claim, there is no court fee before the Consumer Commission. If I am claiming 5 lakh rupees from the opposite party, I'm not paying even 1 rupees as a court fee to the commission. So if the same less than 5 lakh rupees case is referred to the mediation, I have to pay 50% of the mediator's fees. Why I should go for mediation when it is a free in Consumer Commission? That is also the hurdle. And for that purpose, I suggested, see, every national level, there is a National Consumer Welfare Fund. State level, State Consumer Welfare Fund is there. So why not the commission should make use of that fund, especially if it is a less than 5 lakh rupees. And if it is a more than 5 lakh, yes, depending on the rich people, they can, offer, but again, poor people may not. And we can say that anyway, if the case is settled through mediation, the full court fee is refunded. So from that, some share you can give it to the mediator. And if it is failed, then 50% of the mediation you have to pay to the mediator. There also the question comes from where it has to be paid. So these are the practical problems we are, or we can say challenges we are facing, and we are trying to solve that. Another problem here is, if the case has to be disposed of with a due respect to the commissions, if assume that in district only 0.3% of the cases are coming to the consumer commission, and through mediation, if it is settled, and if all the cases are disposed of, then there is a risk for their job itself. Oh, why they should be there? So that somewhere it is clinching them. So that is not a serious issue, but somewhere they are thinking in that angle. So those false assumption, presumption should be removed from these consumer forum members, presidents, so that due to awareness, more number of cases comes and settle through mediation or through the commission. So these are some of the challenges we are having, and slowly we are solving those problems also.
Thank you, sir, for sharing your views in such a great depth. Now, I would like ma'am to please share her views on this. Ma'am, please.
Yeah, I absolutely agree with Professor Dr. Ashok that awareness is the most important and inherent aspect through which we can make people aware about mediation. In our country, people have been looking so far, in that the old system of getting adjudication by some authority. I don't want any particular decision unless or until any authority is passing an order against me or for me. So we leave the decision to third party. We have to make people aware about the mediation process and the mediation centers being attached to these forums. So awareness is must. At state level, there has to be more programs, maybe even radio announcements, advertisements, even slogans, posters. They have to be kept, somewhere in the vicinity where the consumer is going. And they have to display the benefits of mediation, more particularly confidentiality, saving your cost, time and energy, saving your reputation, saving your everything, and you get your needs addressed through this process. See, this process so far under the Act also begins from the forums itself. National Commission, State Commission, or District Commission. They are referring the matter to the mediation centers attached to that. So the people should be made aware about this aspect also, that it is the president or the member sitting there who is referring this, his or her involvement is there. They can make the parties aware about the mediation process and its benefit, refer them to the center, and then any settlement which takes place comes back to the forum only. Forum has to evaluate its nuances and accept and pass an order in terms of the settlement. So what parties decide, they get in terms of order. So people have to be made aware about this thing. For that, we need to adopt some channel by which people are aware about the benefits of mediation. And of course, as we talked about the fee aspect, cost is the biggest hurdle right now. Somewhere or the other, we must get some funds from the state or at the central level, so that in the beginning people are made aware about, and they are provided this service as free of cost, because right now we are looking at the burden on the judicial system. Benefits, they have to be viewed from the party's point of view, but of course the authorities also get a benefit, because by this even further appeals are stopped. So litigation is absolutely scuttled the moment the mediation settlement is made or converted into an order. So awareness is important, and it starts from the vicinity of the district forum, national forum, state forum itself. Of course, at state level, some radio announcements, TV announcements, some awareness has to be given to the parties. And though it doesn't sound too good, but in the beginning, we may have to provide free service also to the consumer, more particularly who cannot afford it. So far as Dr. Ashok talked about private institutions, again, I will say, because that is a big responsibility on the authorities to acknowledge and recognize which institute can be recognized to be providing good mediators. And if you add a quality mediator, then cost also increases. So that is also a lot of responsibility on the authorities to find out. That is why, of course, this act does not talk about trained mediator. But we all know mediation is not what is talked in general or common sense. It is something, a skill. And skill is also, though knowledge may be there, still you have to practice it and then you adopt it as skill. If you use this skill, you can get better results and you can enlarge the pie for the parties. But otherwise, maybe sometimes you can mess up things at the end of the day. So training, I think, though it doesn't focus, the act doesn't focus much on the training, it is important to provide good services. Maybe people can come forward more if they know that the results will also be good. Thank you, Chair.
Thank you so much, ma'am. So now, can I raise my next question? My next question is, what role organizations and companies shall play in order to provide resolution of the disputes to their consumers, so that the consumers take the way towards mediation instead of litigation in consumer courts? I request Professor please to express his views.
Yeah. See, first time in Asia, the government of India, requested the National Law School to establish online consumer mediation center. Under 86 Act, it was not under 2019. In 2015, I was heading that online consumer mediation center as a pilot project. And the disputes, we have narrowed it down, only disputes between e-consumer against e-commerce company. Only those disputes we addressed. And government of Ministry of Consumer Affairs, Government of India issued a letter to all the e-commerce companies, along with the FICCI, CII, ASCOM, saying that here is a mediation center, make use of it. And we also try to contact all these e-commerce companies to settle their matters through mediation. And what was my experience as a director of online consumer mediation? So some mediation, some e-commerce companies, they came, discussed with us, especially Amazon came, around 8-10 people came to law school. Whole day we discussed, and they were happy. They gone back, and later they said our head office not approved for mediation because it is not there under the act. So that's why, so whatever we faced the challenges during that particular 2 years pilot project, we submitted a report to the Minister of Consumer Affairs. So those challenges now we have put it under the new act so that they cannot take those things. And other things, even some of the e-commerce companies, they are not serious or not understanding, I don't know, they are not coming forward, even though it is good for them. What my personal experience, even though I sent a letter, we will sit and discuss. If you have any challenges, why you are not coming forward for the mediation, tell us so that we will improve. The government machinery will improve. But people are not coming forward. And sometimes they think that, I found some of the people that once we come to National Law School, which is the ministry's center is there, or we have to settle the matter, then that record will be there with them. So these types of unnecessary concepts were there. So we face that also. And other aspects, even consumers sent a file a complaint online consumer mediation center, and even some cases opposite party agreed to settle the matter. And even consumer, they don't know that mediation means what. So they said, when opposite party ready to pay compensation, the consumer sends a reply, I'm not happy with only compensation, kindly imprison him. So they don't know what is our power also. So these types of clarity we have to give. So in that angle, see, if it is settled, mediation is a confidential discussion. If it is settled, it will not be in public place, and their reputation is protected. If they are not settling, then consumers are approaching Consumer Commission, and once a Consumer Commission decides the matter, then it's a public document. It is the risk for their reputation. Whosoever, whichever company wants to survive for longer period, growth, nobody thinks in that angle. So that's why what I think still, we have to convince some of the companies that it is a good for them, especially I'm talking about in consumer disputes. My experience is majority on the consumer dispute. My answer or sharing is only on consumer dispute experience. And during that time, what one surprise thing I observed, one of the nationalized bank from Bombay approached me. Sir, we want to settle our disputes through online consumer mediation. What type of cases? Defaulters of non-payment of, they have taken a loan or something they have done, but they have not paid back. Instead of filing, we file a case against them before the civil court. We want to settle through mediation center. So that type of offers also came. So that's a surprise thing I observed. So that type of people are also there, the companies who wants to settle their matters through mediation. And another the risk, especially what I faced, that the Consumer Protection Act says case has to be disposed of within 3 months from the date of notice served to the opposite party. In case of lab test is needed, then 5 months. So that is the timeline. Even though they are not sticking to that, it is a delay is happening, but this is a timeline. Now, if we refer this consumer case to the mediation, then 3 months timeline is given. So opposite party should not misuse that anyway, we will get another 3 months to drag the case. If it is not settled, we'll come back. So that should not be used. So that's why, as the conscious mediator, he comes to know that are they playing with this facility or are they serious? Immediately, mediator has to inform to the commission so that this sanctity of the mediation and trust on mediation of the public should continue. Thank you.
Thank you, sir. Ma'am, what your views, please?
I support Professor Dr. Ashok's view on this. You see, the organizations should come forward and provide somewhere in the advertisements of the product and otherwise in the brochures for providing services, that there is a provision for mediation in case you are not satisfied with the services. So they can start acknowledging the process of mediation at the beginning itself. Like in most of the cases, we find arbitration clause. I think now mediation clause should precede the arbitration clause, and the parties should have an opportunity to go for mediation before approaching any forum for their complaint. So that is one thing they can start. And otherwise also at central level, at state level, even pre-litigation mediation should also be acknowledged and initiated either by these very centers, because now we recognize the center created by any forum. So if this service is provided, so before filing any complaint, the person may be given an opportunity to file an informal complaint with the mediation center at a pre-litigation level, without being imposed with heavy costs that may be less than even what he is supposed to be paying, in the adjudication process. The things may become more public and people may be more friendly to this process. Here, what happens once you file a complaint, then the referral judge becomes the initiator of the mediation process. People feel that now I'm already here, let them decide, why should I go there? So awareness has to start from the service provider side. Service has to be provided at the minimal cost. Comfort of the consumer has to be seen. He should not be burdened with more cost And main thing which awareness is important with regard to is that your needs can be addressed at the very beginning if you initiate the process of mediation, because it is a need-based process. Needs cannot be negotiated at any stage. But what happens? My need is delayed if I go to litigate. So why litigate when you can mediate? These type of the slogans which must be made publicly aware, and people should come forward with open mind and heart at the minimal cost to mediate instead of litigate.
Thank you, ma'am. As we are very time constrained, I would like to raise my next question. My next question is, what is the scope of private mediation regarding the provision of mediation in consumer law? And what are your suggestions to private institutions for taking this benefit of mediation to the consumers? Veena ma'am, please, I request you first.
See, I have already touched this point in my while answering my previous question. So far, people are not acknowledging any mediation center, private mediation center, as we have trust on our litigation process provided by our authorities, by courts. So somewhere or the other, we have to acknowledge, maybe after the passing of the act, things will be coming into force. But so far as act is there, the Consumer Protection Act does not recognize any private mediation. So if we talk about Consumer Protection Act, there is no acknowledgement of private mediation. But we have to provide the facility of private mediation. There, of course, a quality question will come, how to manage the quality control. At that point of time, we will have to look forward to have accredited mediators with good institutions. And for that, we are waiting for the law to come, because they are talking about mediators council as well. So once the council is made, definitely some guidelines will be there, some ethical issues. Right now we talk about morality, we talk about ethics, but all those ethics, vary from person to person. There are no specific guidelines so far. Maybe we will be guided by those guidelines under the act, and things will improve soon.
Yeah, thank you, ma'am. Sir, your views, please.
Yeah. See, when we started online consumer mediation center, the grievance some people came, no binding force for the settlement, because it was under the 86 Act. Mediation was not recognized under the Act. Now we have came out with the chapter, bindingness, everything. But even then, that particular thing, what I'm referring here, the Consumer Protection Act, not nowhere it is recognized pre-litigation mediation settlement. If they recognize that, then maybe the private mediation centers could have got a lot of opportunities. But keeping, this is a system, we cannot change it, but how best we can deliver taking the existed legislation. First thing, I can say that as Madam mentioned, if trust is developed, the private mediation centers, the government trust on private mediation centers, there is nobody stops the state commission, national commission, district commission to recognize those centers. It could be a yardstick and all those things. On that basis, it can be recognized. And presently, to get more experience of the mediation, these private mediation centers can come openly. You know that what type of consumers are approaching consumer commission, less than 5 lakh rupees, no court fees paid. Some, to get the experience of mediation, how it works, why not they come forward pro bono mediation also to develop this particular system. Later, slowly we can shift to the paid one, but beginning for less than 5 lakh, private mediation centers can come forward, say that we will provide service pro bono for who have less than 5 lakh rupees claim. So there, in that way, we can, the private mediation centers can get the more recognition in the public, and state will trust on that. Then the smooth running of recognition of further will happen. So that is my personal opinion.
Thank you, sir. Thank you, ma'am. Quickly, I ask the last question. Is a mediator required to have knowledge of consumer law to have a better outcome in mediation proceedings, or normal mediation procedures are fine? Does it require special training? Ma'am, I request you to share your views on this.
I'm really happy, Shreya, you asked this question, because we have been talking, even as per the Act, anybody can be called a mediator. Two things are important if you really want to have a good outcome of the mediation process. One is expertise in the process, and that you can acquire by undergoing a special training for this. And second, during the training, you come to know this training is not suggestive, this training is not adjudicatory. This training does not tell you to guide people that you do this, because you are not supposed to suggest, because so far in our country, we are doing facilitative mediation. We don't evaluate the rights of the parties. We can't be judgmental. In this facilitative process, what is important is to ask relevant questions. Like you can say there are techniques, communication techniques, negotiation techniques. One technique is asking the right question to the parties during the process of mediation. How one can make that question, how one can prepare that question, unless or until the person does not have the domain knowledge. I want to make it a point, I'm not talking about domain expertise. Experts are not required, but at least you should have the bare minimum knowledge to understand. And of course, if there is somebody who is expert, it will be further better. No doubt about that. But even knowledge is sufficient, because rest you can acquire by reading the concept involved in that particular dispute. It is important for me to know all the consumer law if I really want to help the consumer or the service provider to find out a solution of their choice which is legally implementable. Sometimes I, as an organizing secretary, have seen certain decisions being made by the parties where implementation becomes a very big question. What to do with such type of settlements? So it is important, domain knowledge must be there. Similarly, there should be training to use that domain knowledge in the best possible way to drive the parties to amicably resolve their disputes. Thank you, Shreya.
Thank you so much, ma'am. Sir, what's your views on this?
See, mediation concepts are ethics, concepts are common for all types of disputes. Depending on the parties, the mediator has to change his strategy or use his skill. So here, the consumer, always one side weaker party, not that much stronger party. Opposite party always is a businessman. And businessman always financially in all round, he is a stronger. Here, the consumer is a weaker in all the financial and knowledge-wise, all the angle. So in this situation, if mediator knows why the Consumer Protection Act is enacted, what is the object behind it, and how proceedings happens there, why it is referred here. So if that knowledge is known to the mediator, it is more helpful for him. And sometimes what happens, why some cases are not referred for the mediation, especially one thing, medical negligence resulting in grievous injury or death, that is not allowed for the mediation. So sometimes is here it's a company, they can come out with that is a, we can say what is the intention behind not to refer. So if it is sometimes if it is unfair trade practice is happening, and if it is settled like this, then other victims will escape from that. So that's why some of the cases may not be referred here. So that's why what my concern is, that consumer knowledge helps the mediator to more effectively handle the case and dispose of the case. And consumer expectation is more than in civil court, both parties are they are capable of handling the things, but here consumer may not. What is reasonable settlement, unreasonable settlement? Again, it's debatable, but somewhere you keep the mediator has to keep that particular balance also. He is a facilitator, yes, but at the same time, other aspects also we have to look into. So more, knowledge about consumer commission procedure, about the subject, about the object. If they know it, it is more effective, I can say.
Thank you, sir. Thank you so much. I request now audience to, if they have any question, they can ask from our panelists, please. And in the meantime, I request everyone to please fill out the feedback form already provided in the chat box. Aniket Solanki, you have the question, please. You can ask. Are you there? So there was one question by Mr. Aniket Solanki. He asked question for both the dignitaries: how to spread awareness privately or individually, and how to take the baton in our hands to spread awareness at the practical level. I request Veena ma'am, yes, please.
Manya, I want to address this issue in this way. See, in our Delhi High Court, we are doing even pre-litigation mediation. And who is bringing this pre-litigation matters to the center? The lawyers themselves. Earlier, the lawyers were looked upon, like roadblocks. But now, even lawyers are taken as service providers, keeping in mind the justice which their client is looking for. The courtroom is having now multi-door courtroom. There is litigation process, commission, you can see the president is sitting, courtrooms are there. There is a mediation center. In our Delhi High Court, we have even the arbitration center. We have even the Lok Adalat. So awareness starts from the beginning, from home. So those lawyers who have been litigating all throughout and getting results, even if delayed, through the process of litigation, they notice the benefits of mediation. Many benefits. Professor Ashok talked about confidentiality. Of course, by this you can save your time, money, and energy. Your needs can be addressed. Sometimes you file your complaint before any commission and you keep on fighting till the national commission level. You don't get the results. What is the effect of that? So if a delayed process is there, your need is no more there when you get results. So winner also becomes loser sometimes. Loser in any case is a loser in terms of money and time. So keeping in mind the benefits of mediation, lawyers themselves are advising their clients to try mediation before going for litigation. They support the parties. They guide them. They help them participating in the mediation process along with their parties. They tell them what are the possible options available to them, because this mediation process gives them an opportunity to look at multiple options. Not only the option which is provided under the act, that either the relief is granted or relief is rejected. You can have multiple options, and what option will work the best for their client, a lawyer is guiding. So awareness can be from home. Lawyers, whosoever are practicing in this field, they need to tell their clients that there is a service provided to us. Let us go and mediate. Of course, as I said even in the beginning, at state level, we have to come up with more posters within the vicinity of these forums. We have to have advertisements at various places. We find it even under the Delhi Dispute Redressal Society. You find kahin jahan samjhauta karna ho, you find these type of Hindi ke slogans many a times on roads. So even through radio, through TV, from word of mouth, party to party, awareness has to be made so that people know the benefits of mediation and they opt for mediation before going for dispute redressal through the forums under the Consumer Protection Act.
Thank you, ma'am. So overall, the awareness is the very larger part which is lacking in the mind.
Yes, of course.
Thank you so much, ma'am and sir, for sharing such an amazing eye-opening sessions with us and your experiences, especially, sir. I request sir and ma'am, both of you, to please share your words about any message you want to share with us to Karuna Mediation, to our platform and to our audiences. Sir, please, any message
Yeah.
you want.
First of all, this type of what you are conducting the program, so that's a great. I appreciate this pro bono work also, and that is the way how we can develop the mediation concept or mediation. See, mediation develops. It is directly proportional to the trust. How much trust increases, mediation uh, grows, or it growth will be there. So how we can bring trust in the public and public in general, and disputing parties. So once we develop that particular trust, then nobody can stop us. So challenge is how to build up the trust on the these particular the mediation. So that is the thing. And also in the college days, or whatever, in school or colleges, if even in students have a disputes, there also we can make use of that, that the college level itself they can understand what is this concept, and wherever they go. And this mediation will not help only to the whosoever handles the mediation cases. As a mediator myself, how to behave with my colleagues, how to behave with my friends, how to behave with my relatives. So I will not jump to conclusion whenever disputes are happening. I will coolly think twice and what is happening, go to the grassroots level, then I take a decision. So this type of attitude will help in everybody's life, even though he is not a mediator or handling the cases, but day-to-day life, this skill is helpful for him. So that's why this is that type of the spread, or the information has to be spread everywhere. You may not be become a mediator and handle the case, even it will help you in day-to-day life. Then we can feel that more attraction will come towards this, and in future we will see the more growth of the mediation in India.
Yes, sir. Sir, any message, ma'am, please.
Yes, I endorse what Dr. Ashok has said. As you are already proposing a training in the near future, mediation needs a training, because helping people to resolve their disputes in itself is not mediation. It is a specific skill, and this skill is basically which can help. It is a life philosophy. If you once they will complete this training, it's a life philosophy. It is scientific, it is technical. It is not merely helping two people, please solve your issues like this. No. So this is the training which helps you to understand not merely the dispute, the conflict. This conflict can be within you, it can be within your family, it can be within your society, it can be at national level. So once you know how to understand the concept of conflict, then managing conflict, resolving conflict, finding solution in your day-to-day lives as well, because we negotiate every day within our families, with our colleagues. How should we communicate? What should be the ways of communication? How the communication starts and when does it end? All these are the benefits of mediation training. So once you become a mediator, you can be called a better human being. You yourself will feel a lot of difference in your personality. One. Second is, maybe you do not opt to be a mediator because opportunities to act as mediator in our country are at a very nascent stage, despite having it started in the year 2005. Still, you will understand, as I said, mediation advocacy. In the sense, if you are helping any litigant to find out a solution to their problem, you know how you should act as a good negotiator as an authorized representative for your clients, and you will get the results what your client needs it. And this is the best time, because right now everybody is a consumer oriented market. So is the position with regard to justice. If you get justice to your clients today instead of deferring it to tomorrow, then you will be getting more references from the persons you have got as a client. Many references will come because you are helping them to get what they need today. And that is possible if you use your skills, not only merely as mediator, you can act as a mediator, but how to act as a good advocate in the mediation process also will help you. So I think there is a lot of benefit. You can improve upon yourself as a person, as a professional, and can benefit yourself and the society.
Thank you, ma'am. Thank you so much, sir. And I really appreciate to all the audience for having us for such a period of time and sharing their time on behalf of Karuna Mediation and our founder, Mr. Sahil Kapoor. I hope everyone has filled up the feedback form which is provided in the chat box. And thank you so much, ma'am and sir, for your very precious time for having us on their busy schedule. Please.
And another thing, last year, ministry requested me to write a book for a layman on consumer mediation. So that was released by Piyush Goyal, Cabinet Minister, last year. That soft copy is available on the Ministry of Consumer Affairs as well as our National Law School website. Anybody can download that soft copy of the book.
Sure, sir. So thank you so much, ma'am and sir. Thank you everyone for your lovely time. Thank you.
Pleasure talking to all of you. Thank you.
Thank you, ma'am. Thank you, everybody.
Thank you. Namaskar.
Thank you, sir.
Thank you.
Namaste. Namaste to everyone.